Good day, Crime Talk aficionados. We have a big show for you today since I missed yesterday. Sometimes things come up. First on the docket, more sanctions for the prosecutors in the Barry Morphew case. One of the former investigators in the Delphi murder case, a potential defense witness, well, he's been arrested and charged with official misconduct. Sarah Boone's trial, the trial that was never going to be delayed, well, it got delayed. Blame it on the hurricane. It's time for another competency evaluation for Lori Vallow, another case where a woman planning a divorce from her husband ends up dead. We have judges being shot by sheriffs. Guess what? A pastor said, "Hold my beer." And another mob riot in LA, another teacher in trouble. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, listen, things come up in life. We were all ready to go, and then, well, it just didn't quite turn out that way. Welcome to life. Anyway, we have a great show for you today, but before we get there, we need to pay a couple of bills. Go to CrimeTalkSearch.com. Sign up for that background subscription service today. You're going to be surprised on what you find or maybe don't find about a particular individual. Now, when you have this background subscription service, you can do as many searches as you desire. And it's on anyone here in the United States. And that report is literally going to be generated while you wait, and you're going to get all kinds of information. Do they have bankruptcies? Do they have liens and judgments against them? Do they have a criminal history? Are they on one of those public registries? All that information, ladies and gentlemen, that you want to know when somebody new is coming into your life. Come on. You know you want to go search somebody. You know you do. Go to CrimeTalkSearch.com. Remember, you can cancel at any time. All right, let's go ahead and get to the docket for October 8th of 2024. And first on the docket, more sanctions for the prosecutors in the Barry Morphew case. Now, as you may recall, the lead prosecutor got disbarred for her conduct in the Barry Morphew case. But two very seasoned deputy district attorneys have received public censures for violating the Colorado Rules of Professional Conduct during the Barry Morphew prosecution. Back in 2023, Protect Ethical Prosecutors, a national project that aims to eliminate absolute immunity and protect ethical prosecutors, filed a request for investigation with the Colorado Office of Attorney Regulation to look into the alleged misconduct of Robert Weiner and Mark Hurlburt. Now, both of these guys have been practicing law for probably over 30 years. Mark Hurlburt was the elected prosecutor up in Eagle County years ago. He was one of the prosecutors on the case against Kobe Bryant that was ultimately dismissed. Bob Weiner, who I've known for 25 years, always, in my opinion, very ethical and honest prosecutor, and very surprised by both of the allegations by everybody. But clearly, Linda Stanley, the lead attorney in this case, was truly responsible. But let me tell you some more. So rather than moving forward with the formal hearing, which was slated to happen this month, Weiner and Hurlburt agreed to settle the complaint with a public censure. Smart thing to do. Would you risk being disbarred? No. You take the public censure. So the statement that was put out says, "It's disheartening that Mr. Weiner and Mr. Hurlburt's desire to win at all costs impeded their judgment and damaged the public's faith and trust in the criminal legal system." And this was a statement by Iris Eitan, founder of PEP, and attorneys for Barry Morphew, in his civil and criminal case. Now, last year, multiple requests for investigation into the DA's office were submitted to the Office of Attorney Regulation Counsel. In April of 2023, Iris Eitan called for Stanley's disbarment or the severest sanction possible against Stanley and other prosecutors who worked on her client's case. Now, a state panel disbarred Stanley in September for ethical violations and misconduct. She filed a notice of appeal with the Colorado Supreme Court this past Monday. Now, Morphew, as you may recall, was arrested in connection with the disappearance of his wife, Suzanne Morphew, who went missing back on Mother's Day back in May of 2020 there in Chaffee County. Now, Stanley assigned Hurlburt, who had been a prosecutor for 28 years at the time of this alleged conduct, to assist with the Morphew case back in July of 2021. He worked as a deputy district attorney in 2019 and 2020 for the 11th Judicial District before being rehired on a contractual basis to handle prison cases. He was prosecuting a cold case homicide and another multi-defendant homicide that occurred at the Department of Corrections when he was assigned the Morphew case. Now, at the end of October 2021, Bob Weiner, who had worked as a prosecutor for nearly 30 years, was retained to assist with the prosecution of Barry Morphew. He continued to work a full-time private practice while actively handling numerous significant civil cases. Now, according to court records, after the presiding judge in the Morphew case, Ramsey Lama, issued a series of rulings adverse to the prosecution team, Linda Stanley texted the prosecution team a link to an online change.org petition that called for investigating and possibly removing Lama from the Morphew case. The petition alleged a conflict of interest, citing the judge excluded evidence of domestic violence, that Lama's ex-wife was an advocate for Suzanne Morphew and victim of domestic abuse, and the ex-wife and Barry Morphew belonged to the same gym. Now, Weiner suggested an interview with Lama's former wife, to which Hurlburt agreed. This agreement to interview Lama's former wife rather than raise the matter directly with Lama or Morphew's defense team amounted to a reckless attempt to uncover a conflict or other information that might be cause for judicial recusal, according to the court records. Now, in his text, Hurlburt endorsed his course of action to Stanley, a less experienced prosecutor, and even after Hurlburt and Weiner learned Stanley planned to have her office investigator, rather than an independent entity, interview Lama's former wife, they failed to take any affirmative steps to deter or prevent Stanley from proceeding with an interview, thereby participating in an attempt to prejudice the administration of justice, which is in violation of the rules of professional conduct. Now, back on April 19th of 2022, just days before the homicide case was to go to trial in Fremont County, the DA's office dismissed all murder charges relating to the case of Barry Morphew, claiming they believed her body was buried under deep snow and they could not access the location prior to trial. Now, remember, her remains, Suzanne Morphew's remains, were found in Saguchi County in April of last year. Now, in retrospect, Hurlburt has remorse, and he did not caution Stanley, according to the censure. He recognized the potentially negative perception of the judiciary and the public interviewing a presiding judge's ex-wife, and he is agreeing to accept the discipline as a result. Now, Weiner's records also indicate, although at the time he did not believe it was improper to discuss investigating conflicts involving Judge Lama, in hindsight, he does regret not objecting more forcefully to Stanley's plan to interview Judge Lama's ex-wife. He recognized the potential negative perception of the judiciary and the public interviewing the presiding judge's ex-wife, and confirmed his acceptance of discipline here. Now, according to the agreement, Mr. Hurlburt must pay $4,894, and Mr. Weiner will pay $4,729 in costs associated with their case that was brought by attorney regulation. Now, neither Mr. Hurlburt nor Mr. Weiner had any prior discipline matters prior to this case. Like I said, my interaction with Bob Weiner over the years was more extensive than Hurlburt, but I've dealt with them both. My experience was that they were both very ethical, skilled attorneys. I think what this shows is that sometimes people, no matter how ethical they are, can get caught up in the heat of the moment of trying to win rather than doing justice, which is the calling and the ethical standards for district attorneys. Now, as you may also recall, Morphew filed a $15 million civil rights lawsuit back in May of 2023, alleging the now dropped criminal prosecution violated his constitutional rights. He alleged malicious criminal prosecution in his wife's disappearance. He sued the Chaffee County, the sheriff's office, the Board of Commissioners, Linda Stanley, and members of her staff, as well as the Colorado Bureau of Investigation, as well as several FBI agents. And we brought you the news a couple weeks ago The federal judge dismissed that lawsuit back in September of this year, citing governmental immunity. You can't sue the king, ladies and gentlemen. That's why it's called governmental immunity. Couldn't sue the king. The king has to give you permission of the areas in which they can sue you. And then they say, you can't sue us. It's governmental immunity. We didn't give you permission to sue us. Case dismissed. It's kind of like a long-held principle that your government officials get immunity for the official acts that they participate in. Otherwise, they would be frozen, the old paralysis by analysis, because they couldn't make a decision. What if they were wrong? What if they weren't wrong? What if it turns out bad? Are they going to fire me? Could I get sued? So they get immunity. So no matter how poor decisions they are, nobody ever gets fired. Well, in this case, Linda Stanley got disbarred, subject to an appeal to the Colorado Supreme Court. Next, the Delphi case. The former Rushville police officer, a guy by the name of Todd Click, has been released on his own recognizance after being arrested Friday. Now, Click, who is a former police officer there at the Indiana State Police agent and former Department of Child Services investigator, was charged with official misconduct, forgery, and falsifying child abuse or neglect information. He's accused of filing protective reports detailing his visits and phone calls to troubled families. Those families say Click never actually called or visited their residents and therefore lied. Now, Click's initial hearing was held Monday morning. He was released on his own recognizance, as I noted. A pretrial conference is set for November 12th and another set in January of 2025. As you may recall, Todd Click was once thought to be one of the strongest witnesses for the attorneys in the Delphi case representing Mr. Richard Allen. Now, Allen is obviously charged with the double murder of Abigail Williams and Libby German, and Click was part of the three-man investigative unit formed back in 2018 to investigate potential ties between the girl's murder and men in the Carroll County area with ties to Odinism and the ritualistic killings. That unit was disbanded after the 2020 murder of Detective Greg Pharisee, who was also a member of the Odinism investigative unit. Now, Click testified earlier this year that he came forward to the Carroll County prosecutor, Nick McClellan, after Richard Allen was arrested in 2022 and expressed concern about the substance behind Allen's arrest. Click felt prosecutors, including McClellan, did not have a strong case against Allen, and that there were other men who Click felt made much more stronger suspects in the murders of Williams and German. Now, Allen's defense has long held that the belief that these men have ties to Odinism killed the girls as part of some sort of pagan sacrifice. Now, the judge, Judge Gull, in this case, has ruled that the defense is no longer allowed to bring that information before the jury trial that begins on October 14th. That also includes information that the defense may have had on Ronald Logan, Keegan Klein, as well as other geofencing data and more. Now, part of the reason that it's not going to be before the judge is that the prosecutor objected to Click's assertions, claiming that Click may have a history of lying. It's almost like he knew something, like maybe charges were coming down, right? Anyway, McClellan then requested Click's employment records. And like I said, Click was a former police officer before he was part of the Delphi investigation. Like I said, now he's facing felony misconduct charges related to his work at the Department of Child Services. Mr. Click has repeatedly said that he and two other investigators strongly believe at least 3 people were involved in the murders. When a search party found the bodies of the young girls, Abby and Libby, in the late morning of February 14th of 2017, they had been missing for roughly 22 hours. Defense attorneys for Mr. Allen say that the girls' deaths more than 5 years later have since been described as a ghoulish scene. One of the girls was found at the base of a tree with 4 tree branches in various sizes intentionally placed in a specific pattern on her naked body, which was covered in spots of blood. The attorneys wrote in their filings previously submitted to the court. The other girl was discovered a few feet away at an angle. Defense attorneys wrote in their documents saying that her arms and legs were posed at different angles, fully clothed but not having any blood on the clothing. She was likely murdered while naked and then dressed by the murderers after she passed away and after the blood had stopped spilling from her neck. Like I said, the defense attorneys lost their motion, and none of this will be before the judge. Judge Gull none of this information will be before the jury. That's because Judge Francis Gull denied the motion for the defense to present this alternate suspect information. Now, Judge Gull did not close the door entirely on Allen's defense team, noting the court will allow Allen's attorneys to argue during trial why the evidence should be admitted. These offers of proof are going to be done outside the presence of the jury, and then the judge will decide at the bench whether the evidence comes forward. A lot of it's going to depend on how the evidence is presented at the time of the trial, which is frankly what the defense probably should have done rather than seeking the pretrial determination, which forced the prosecutor to say, no, you shouldn't do this at all, and then they got denied. Sometimes if you're not sure it's going to come in, it's better to beg for forgiveness than ask for permission. Just go do it. The defense was relying upon several law enforcement investigators who theorized the possible odonistic involvement in the girl's death. But like I said, the judge ruled that no physical evidence existed and the theory would only serve to confuse jurors. But the evidence will still almost certainly include descriptions of what investigators found at the scene, which the defense team linked to this white nationalist who hijacked a pagan Norse religion called Odinism. Following of such a movement would have killed the girls using rituals they co-opted from the religion, they said, and they left behind such symbols as the runes made from the tree branches. When the defense attorneys offered their complicated theory of why their client was wrongfully implicated in the Delphi case, they included the allegations of law enforcement ignoring the involvement of known Odinists who posted photos on social media that they looked remarkably like the scenes from where the girls were found. The defense says the crime scene is chock full of signs of cult involvement, and the defense also believes that the Department of Correction officers in the state prison system guarding Mr. Allen while wearing those various patches on their Indiana Department of Corrections uniforms with Odinistic symbols or that read, "In Odin we trust." Now, in affidavits later filed with the court, the Westville Correctional Facility, specifically Officer Randy Jones and Joshua Robinson, admitted they wore at the time, but later removed patches that can be associated with Odinism. They deny being a part of a cult. Now, the Delphi murder trial is scheduled to begin on Monday, October 14th, with jury selection and for the first several days, and testimony should begin by October 18th. Now, remember, because of Judge Gull, news media is restricted. Note-taking with pen and paper only is the only acceptable form of reporting allowed by Special Judge Francis C. Gull. There you go, ladies and gentlemen. I can't wait. This one should have been televised. I'm always skeptical. Like I said, free speech advocate here. Also an advocate that video should be in every courtroom, everywhere, so we can see how the trial's going, how the general courts are conducted. They work for us, the people, they being the courts, the court system, and everybody should be able to see. And with modern technology, we should be able to bring it to everybody. And so the fact that Judge Francis C. Gull is denying the world, let alone the people of the great state of Indiana, access to one of the biggest trials in their state's history, well, I just think it's a tragedy. Next, the Sarah Boone trial. Well, it practically would be over by now if we had started. And the judge who said he would never continue the case, well, he continued it. Not because he wanted to, but because of the impending hurricane. So jury selection is going to begin next Monday for the woman accused of murdering her longtime boyfriend by zipping him inside of a suitcase and leaving him to die. Sarah Boone is charged with second-degree murder of the death of Jorge Torres, who was found dead inside a suitcase inside the couple's shared apartment back in February of 2020. Now, in a series of interviews at the crime scene the next day, the Orange County Sheriff's Office, Boone told investigators that Torres had willingly put himself into the suitcase while the couple was playing a hide-and-seek game after a night of drinking. Because everybody does that. That's so normal. Anyway, the prosecutor said the key evidence in the case includes 2 videos found on Boone's phone that were recorded while Torres was in the suitcase. The video features the victim begging to be let out, with Miss Boone laughing and taunting him. Now, Miss Boone told police she went up to bed shortly after the videos were taken and fell asleep, leaving Torres inside the luggage. Once again, that's totally normal. Now, Miss Boone is being represented at trial by an attorney by the names of James Owen, a very brave man, because he is now her ninth attorney in the case because she could not get along with anybody else. Mr. Owens has volunteered to step in as her lawyer after the judge ruled she had forfeited her right to have an attorney. The ruling followed 8 other attorneys withdrawing from the case, citing Ms. Boone's behavior as an issue. And Ms. Boone has been vocal about her own defense, writing a number of letters to the judge and even creating an advertisement for a lawyer that eventually caught Owens' attention. Owens has filed an intent to use a battered spouse syndrome defense in the case, citing years of domestic abuse and arrest records of Mr. Torres against Ms. Boone while they were in their relationship. Now, back in October, Ms. Boone rejected a plea offer from the prosecutors that would have sent her to prison for 15 years, and she would have had to have pled guilty to manslaughter. But now she faces a minimum of 22 and a half years in prison and a potential life sentence if she is in fact found guilty. Like I said, jury selection was supposed to begin October 7th. Now it's going to be October 14th. And we'll bring it to you live, ladies and gentlemen. We'll bring it to you live. Next on the docket, it's time to get another competency evaluation for Lori Vallow. Now, I'm sure her attorneys in Arizona have contemplated doing this, but she has ultimately been found competent, and she went to trial and was convicted and sentenced in Idaho. She called her son, her oldest son, Colby Ryan, and they had a phone conversation. And I'm not really sure, how cool it is to record your mom and maybe not tell her that you're going to record the call. But his mom called from the Maricopa County Jail in Arizona, where Lori Vallow is awaiting a trial on conspiracy to commit murder charges in relations to the death of previous husband, number 4, Charles Vallow, and Brandon Boudreau, her former nephew-in-law. So Ryan put up a video of a conversation, 64 minutes in length, on his YouTube channel. And it's the first time he's apparently spoken to his mom in 4 years. And like I said, Lori Vallow is serving multiple life sentences, so it's not like she's ever going to get out. Those multiple life sentences are for the death of JJ, Joshua, and Tylee Ryan, as well as Tammy Daybell, the wife of her current husband, number 5, Chad Daybell, who's also serving a death sentence in the Idaho Department of Corrections pending the appeal. Anyway, some couple of things that jumped out during this interview call is at first that Lori Vallow maintains that she is following Jesus and she's just doing her job. There is a higher knowledge, she let everybody know, for people who need to know it, and people who don't need to know it don't need to know it. And when it comes directly from Jesus to her, directly to Lori Vallow, and it doesn't come from any other source. It comes from Jesus Christ directly to her. Now, Vallow stood by the statement she made during her sentencing that nobody was murdered, rather accidents, suicides, and fatal side effects of medications are what took place. So basically, she blamed Tylee for the death, saying that shortly after the family moved to Rexburg, Idaho, her daughter was mad at her. And then Lori Vallow insinuated that while Tylee was babysitting JJ at the apartment, she accidentally killed him and then took her own life. Yes, the old murder, suicide, let's dismember and burn myself case. Yeah. Anyway, Vallow told her son that once she found her dead children, she ran out and someone else did something with the bodies. She says, I wasn't aware what happened to them after I left the scene. The spirits were gone from their bodies and they were already in heaven. Now, after the children died, Vallow said JJ and Tylee visited her, presumably in the spirit form. And apparently Tylee told Lori, I'm sorry, Mom, for being such a brat. Tylee and JJ then visited right after that again and saying that it wasn't her fault because she was blaming herself. She said that she didn't want anyone to know what Tylee had done to JJ, and she wanted to continue to protect Tylee as her mother, who had been trying to protect her for her whole life. Anyway, Ryan told his mom, hey, he doesn't believe her claims and that she is beyond deceived. Lori Vallow responded that her case has been blown out of proportion, that the media flood against her is from Lucifer. Anyway, Ryan ultimately tells his mom, hey, listen, I got no malice towards you. I forgive you. He says, I'm not going to hold you in a jail cell in my heart, but you cannot be a part of my children's lives, and you and I can't even be a part of each other's lives. He says that he doesn't know his mom anymore. Anyway, Vallow replies that her mission will eventually be revealed to everyone, and she began to cry while telling her son nothing could have been done differently. Needless to say, Ryan firmly states that Tylee had nothing to do with the deaths before he broke down sobbing on his podcast. And I don't know, get her some mental health treatment. Somebody needs to smack her along the face, figuratively, right? We don't abuse people in prison. But, maybe a son could smack her upside the head and say, Mom, snap out of it. Snap out of it. You're not looking at the evidence there, Lori Vallow. Her attorneys may want to comp her. She may not be able to assist in her defense down there. Anyway, we'll have to wait and see. Next on the docket, a husband crumbles and confesses. And guess what? The wife was seeking a divorce. Shocking. And guess what? She wound up dead. So in less than a day, an Indiana man went from reporting his wife missing to confessing that he actually beat her to death with a hammer. Yeah, please meet Daniel Keith Flattery. He's currently held without bond at a jail in Gibson County there in Indiana. A probable cause affidavit alleges that Kayla Flaherty went missing. He allegedly asserted that she left their home at approximately 1:30 a.m. on October 3. And according to him, she had been heading to her mother's home, but her mother ended up telling investigators that Kayla didn't show up Thursday morning. Anyway, Dan Flattery advised that Kayla was going to go to her mother's house located in Vincennes, which is in Knox County, Indiana. Dan then advised that Kayla will typically text him and let him know of her arrival, but she did not in this particular situation. And because he loved her, he contacted the police. Anyway, when the police searched the route they believed that Kayla would have been traveling upon, they found nothing. And Kayla, who was scheduled to work at the Good Samaritan Hospital on Thursday, also did not respond when her employer called her off that shift that day. Well, guess what was discovered? They discovered that Kayla Flattery had recently filed for divorce from her husband. And although Daniel hadn't been served the divorce papers, he advised that when Kayla left the house, they were having a discussion, ladies and gentlemen, about her relationship, their relationship, which ultimately wound up with him beating her head in with a hammer. Yes, now we'll give him the presumption of innocence, but he did confess. Anyway, the defendant allegedly gave information that his wife's credit card was used at a Huck's gas station in the city where his mother-in-law lives, and a license plate reader captured her vehicle at 11:50 p.m. on October 2, and the defendant allegedly told investigators that she had returned to the house after that time, according to the affidavit, and she was bringing a backpack. When investigators checked her cell phone history, guess what? They tracked her location within Gibson County, but there was no indication she was headed towards Vincennes in neighboring Knox County before her disappearance. And then guess what? The couple's 2019 Toyota Highlander had a feature for vehicle tracking. But when defendant Flattery contacted the company to turn on the feature, they said they couldn't do so despite their repeated attempts. Ultimately, Mr. Flattery, the defendant, told investigators with the sheriff and state police that he had in fact struck his wife multiple times with a hammer in the living room on Thursday morning. He then admitted that he rigged the vehicle to drive it into the Wabash River and set fire to the Highlander along with the body of Kayla. Guess what? Daniel further identified the location of the site via a map and pointed out a location in a far southwest Knox County area there in Indiana. Investigators checked out the spot, and guess what? They found out a burned Toyota SUV with human remains inside. Search of the vehicle located the remains of Kayla, her cell phone consistent with statements being made by Daniel that identified other items of property as well. Now, an initial hearing was held, and Daniel was advised of the charges and his rights. The court found probable cause to arrest him, entered pleas of not guilty on his behalf, and he requested a public defender. All right, ladies and gentlemen, there's a lot going on in the world. It just seems like it's crazy. We've got sheriffs shooting judges, and now, guess what? This pastor said, "Hold my beer." A Missouri pastor has been granted bail 2 years after he allegedly shot his wife's lover after he caught them in a restaurant together. Now, Matthew Dedman has been charged with first-degree murder regarding the armed criminal action for the May 28th, 2022 shooting of Joe Newbern. Police allege the Dedman, a pastor at the Heritage Baptist Church, drove to the Ozark Square and observed his wife with Newbern at the Iguana Roja Restaurante when he confronted them. He's been sitting in the county jail without bail or a trial until October 1, when the judge granted him a $30,000 bond. Apparently, the case has been slowed down by a lot of fights over motions to endorse witnesses to testify and discovery issues. Anyway, apparently the judge thought whatever was going on, it was egregious enough to give a man who had no bond a $30,000 bond. Now, here's the catch. Mr. Dedman is still in custody. He has not made the bond. But it is alleged on the date of the incident that Mr. Dedman got out of his truck holding a pistol and went to confront Newbern about the affair. And then he allegedly shot Mr. Newbern 3 times in the chest, according to the police. And then they found the gun in the pastor's truck. The Ozark Police Department said they had arrived at the scene. They found the victim located in the roadway with multiple gunshot wounds, and he was pronounced deceased shortly later at the hospital. The trial is now scheduled to begin for the pastor shooting the philanderer on March 3rd, 2024. And then in L.A., we have a mob of California teens that stormed and attacked and robbed a 7-Eleven in a violent rampage as an employee hopelessly tried to fight them off. Take a look at this video. It shows, I would say, an aggressive group of teenagers pulling the convenience store doors open as the employee attempts to stop them. But the mob made their way into the store using forceful and violent tactics. The employee was eventually hit in the stomach by one of the boys and collapsed to the ground in pain. That's when the mob came in. The clerk grabbed a broomstick and used that to defend himself. But as one boy was wearing a gray sweatshirt, was seen threatening the fighting employee while the rest of the group destroyed and robbed the store. One aggressor ripped a display of lighters from the counter, shelves were knocked over, and a group of members climbed over the counter, leaving the store in an unrecognizable condition. After taking too many hits, the employee appears to admit defeat, and he walked away from the group. He had a bloody nose. While leaving the store, the teens are each seen holding armful of chips, cases of beer, and other items. They seemed joyful after they left the 7-Eleven, completely destroyed. Obviously, most of the people had their faces covered and had their hoodies on. That's what hoodies were designed for. I don't care what you say. I know hoodies came into existence in the 50s. But listen, if you're going out on the streets in the middle of the night, wearing a mask, there's no COVID going on anymore. Come on, ladies and gentlemen. Give me a break. Doesn't take a rocket scientist to figure out what was going on. Anyway, that ransacking took place at 1:30. Of course, the LAPD is working on it, and they're going to do their best to solve this case, but they don't have a whole lot of leads. So if anybody knows who these culprits were, let them know. Next on the docket, another teacher in trouble. A teacher in Garden Ridge, Texas, has been arrested after she was caught engaging in sexual contact with a juvenile, according to the police. On last Thursday, about 6 p.m., the deputy sheriffs were called to the home under construction in the Citadel Point area there in Garden Ridge in regards to this call. Deputies made contact with a woman by the name of Jennifer Massey, an art teacher at Davenport High School, according to the school website. According to the investigation, Miss Massey and the juvenile were engaging in some sort of sexual contact. Miss Massey was arrested and faces improper relationship between the educator and the student. Now, Miss Massey's bond had not been set, but guess what? The school has put out a statement saying that we do not condone inappropriate relationships between teachers and students, because we are here to ensure the safety and security of our students, and that is our top priority. And they're going to continue to cooperate with law enforcement during this investigation. The principal also said the purpose of this message was to make the parents aware of the situation, that one of their teachers, Jennifer Massey, was involved in this situation with a student, and that it was completely improper, and that Miss Massey will not be joining the school yet again. Next on the docket, this day in legal history. Let's do yesterday since we missed it, and we'll do today. But yesterday in legal history on October 7th, the United States Supreme Court held its first session in New York City. And although the initial session did not hear any cases, it was significant because it marked the beginning of the judiciary's function under the United States Constitution. And then in today's legal history, on October 8th, 1918, the United States Supreme Court struck down the Keating-Owen Child Labor Act of 1916 in Hammer v. Dagenhart. The law had aimed to regulate child labor by prohibiting the interstate shipment of goods produced by children under certain ages. However, the court ruled that it exceeded Congress's power under the Commerce Clause, asserting that the regulation of child labor was a state matter rather than a federal matter. This ruling was eventually overturned in 1941 in United States v. Darby, which upheld federal labor regulations. That was after FDR, good in some ways, but he was completely terrible in others because he attempted to stack the court to get the judges on the court, and the judges basically relented and said, fine, the federal government can do anything. And here we are today with 428 federal agencies because, well, they can do just about anything. They can do no wrong, all because of that particular case, ladies and gentlemen. America has never been the same. It used to be, it's a republic, ladies and gentlemen. State rights were supposed to be superior to the federal rights. The federal government did very little, right? Have an army, protect the borders, regulate trade, immigration. That was it for the feds. Everything else left to the states. Now, if you're going to steal a getaway car, maybe pick something with a top speed above 25 miles per hour. Please meet Donald John Clark. He didn't do such a smart thing, and that's why he's our dumb criminal today. No, what did he do? He stole a 20-ton front-end loader and led the St. Petersburg police on a 90-minute chase that could have been outrun by a bicycle. It started when police got a tip about Clark driving erratically on a $250,000 Volvo L11 OG, the big front-end loader. Clark blew through some stop signs and curbs, and officers were keeping pace with him. They were unable to stop him, obviously given the size of the machine. And the man driving the loader disregarded the officers' emergency lights and sirens. How dare he? Eluding. And he was driving to adjacent neighborhoods, going over curbs and running stop signs, according to the police. Officers tried blocking Clark's path, but on several occasions, the loader operator drove directly at police cruisers, narrowly missing them as they moved out of the way. Sounds like attempted murder to me. Anyway, Clark plowed around town, ignoring the lights and sirens. Officers had no immediate means to stop the loader and just attempted to maintain visual on him until the opportunity arose to arrest him. Eventually, the loader ran out of gas or electricity, but Clark wasn't done. He ditched the machine and took off on foot, only to be arrested after being tased. I like the nice electrical part of it near the end to keep it with the electric loader. Mr. Clark, you are a dumb criminal of the day. Congratulations, you made it. All right, ladies and gentlemen, that's all we have for you today. Have a wonderful day. We'll see you next time. Yes, the Constitution matters.